Mr. Brown.
Do your lordships have anything arising over lunch that you'd like me to discuss now?
Not that I detect.
I think, if I may be permitted to just go back to the First Tier Tribunal case in this case, because of course it is, in terms of the respondent's case in this, the wider context almost doesn't matter, because it's central to this appeal. So, just going back, if I may, what the appellant was faced, I can invite you, if I may, to go to the supplementary bundle. Page 107. This was the Commissioner's skeleton argument in the First Tier Tribunal. Sorry, giving you a slight bad reference. It's 105, I beg your pardon. Paragraph 7. You see the decision of the Commissioners was, in this case, Mega Marshmallows products can be used, sold for use as an ingredient in home baking, provided they do not fall within the accepted items.
Sorry, where are you reading from?
Paragraph 7, my lord, page 105. Commissioners decide the product should be standard rating, despite the fact they are, or the assertion was they're perfect for toasting, s'mores, etc. And then moving forward to page 107, paragraph 14. The only issues for determination in this appeal is whether Mega Marshmallows are confectionary. The issue is not an issue of law, but of one of fact. HMRC contend they are confectionary and therefore standard rated. The appellant, now the respondent, contends they are not and should be zero rated. Over the page, paragraph 15, subparagraph 4. The Commissioners set out what Note 5 says. So that was the case faced by...
To be fair, you need to look at paragraph 17 too, don't you?
Yes, sorry. So that was the case that was...
And just, they're very much on this page, at least, pinning their colours to the mast of Note 5.
They certainly mention it, absolutely.
Right, because that's paragraph 17,
yeah,
20, 21.
Yes, absolutely.
Yeah.
The evidence put forward by the appellant in the First Tier Tribunal. So we're now back at the core bundle, if I can invite your lordships to put away the supplementary bundle now. I don't think we'll need it again. Page 159.
So what is the point that we've just looked at that for? To show that they were putting their case on Note 5 or something else?
Yes, no, that was it, my lord.
Oh,
that was
okay.
it. Yeah. For the purposes of saying the First Tier Tribunal must have had it in mind when it was making its decision, because that was the basis of the Commissioner's argument.
Yes, I see.
I see. Yeah, thank you.
Page 159 of the core bundle behind tab 14. paragraph 39 by the first hole punch. You see where I set out the factors that tended to suggest that the product was not properly characterised as confectionery. So number one is, you can see where it's not normally eaten with the fingers, it's roasted on a stick. And then items 2 through to 6 in effect is about the roasting of the product. So that was the case that the tribunal, First Tier Tribunal, had to look at, and as we've said before, it decided, one would infer at least, that it didn't need to consider Note 5 because it decided on the ordinary meaning of what confectionery was. Something had happened or was going to happen to the product. It meant when it was consumed, it was not confectionery. And the respondent says that that has to be correct, because there seems to be a danger here that the parties are in danger of inviting your lordships to go down a rabbit hole, because what's being considered here is what is confectionery.
When you say that has to be correct, do you mean the FTT must have been correct in considering the broader question of whether it was confectionery?
Yes. Well, let me put it another way, if I may. It was not wrong.
But according to what you've just shown us, it was not the case advanced before them by the revenue.
No. But it was the appellant's case.
Yeah. Okay.
And so therefore, when I say going down a rabbit hole, there's a danger that if the commissioners are correct, if the tailpiece is everything, it's something that's normally eaten with the fingers, is in effect an deeming provision, then one would have thought that the legislation would have simply read that. There's no need to put anything else. Confectionery is something that's normally eaten with the fingers. Sweetened and
it obviously isn't just that.
No.
I mean, the Note 5 doesn't purport to be an exhaustive definition any more than the note explaining that food includes drink is an exhaustive definition, because it obviously includes things that aren't drink.
Indeed, but there seems, maybe I'm mistaken, there does seem to be an emphasis from the commissioners that the tail end of Note 5 is so wide and so expansive that it includes many, many items that were not previously to be included in confectionery. The respondent's submission is that simply isn't correct.
When you say it includes many items not previously included, can you give us some examples?
Well, I can't, Milo, because it's not my proposition. I say it's not that significant and definite widening. I'll address you on mini marshmallows, if I may, in a moment.
Yes.
I'm sure you'll be delighted. But it can't have that wide definition that commissioners say it has. And to put it bluntly in a rather pithy way, if that's what Parliament intended, they forgot to tell anybody. They simply say that the primary mischief that it was trying to correct was cereal bars. That was the primary mischief that it was trying to correct. And if I may address you slightly, if I'm going off piece, please bring me back. But in terms of the issue picked up earlier over always speaking principle, then I don't push that at all. It was merely, I think, my ham-fisted way of trying to say what Parliament intended, looking at it from a purposive approach, was to give the First Tier Tribunal that ability to look at the product, to carry out a multifactorial assessment before reaching a decision. But even then, when that MFA has been carried out, the question was, well, is that the end of the matter, subject to absurdity? Well, even on the Commissioner's own case, they can't say what the correct treatment of mini marshmallows is in terms of the basis for it being carved out from Note 5. It may be a concession, there may be other ways. And what that means is, if the tail end is somehow definitive, then it's got to be unworkable. If you can just carve out items. Because mini marshmallows are marshmallows.
I thought that what Mr. Watkinson told us was that mini marshmallows are not normally eaten with the fingers because they're normally consumed in other ways. Therefore, they don't come within the tailpiece.
He did say that, but he did say also by concession.
Yeah.
Well, that's a separate point, isn't it? That's whether they come within the normal meaning of confectionery. We've always got to keep those two separate questions separate.
I'm not quite understanding that, my lord.
Well, one question is whether something comes within the normal meaning of confectionery.
Correct.
And for that purpose, you ask the normal person in the street to carry out a multifactorial assessment, and when he's done it, he tells you the answer.
If it requires a multifactorial assessment.
But the separate question, according to Mr. Watkinson, is whether it comes within the tailpiece, which mini marshmallows plainly don't, if they are not normally eaten with the fingers.
I would say the question has to be one and the same.
Right.
I don't see how you can say, well, is it confectionery according to the ordinary man in the street, and then also have to consider Note 5.
So you would say then that the Corte di Letto case, which we were shown earlier, which said there are these two ways in which you may get home as saying something is confectionery, is wrong.
Well, what I'm saying is, certainly in terms of Corte di Letto, just to be clear, it was neutral on whether Note 5 was a deeming provision, an inclusive, exclusive, or expansive. It didn't make any.
Well, I don't particularly find it helpful to apply those terms.
No,
to
indeed.
the kind of provision it is. But,
And
what it clearly said is that there are two ways in which something may be confectionery. One is it's within the normal meaning. The other is that it's within Note 5 or the tailpiece to Note 5.
But I do disagree with that, because the idea is what is confectionery. That's what's being construed. There's no need for a two-stage test unless they are, well, they should be all part and parcel of the same test. The First Tier Tribunal was correct to say, well, something happens to this product, which means it's no longer confectionery.
We can see, I'm sure that's not admissible, but we can see from the materials annexed to the intervener's skeleton that the revenue customs, I suppose at the time, thought it was a good idea to have legislation because there was a problem about cereal bars. Because hard cereal bars might be thought to be akin to biscuits and therefore zero rated.
Yes.
On your case, can they still have that argument?
They being who, my lord?
Manufacturers of hard cereal bars.
Well, yes, they can, I think, depending on what the composition is. And this is the dual fuel case that's stood over. There has to be a multifactorial assessment, or at least a factual assessment for every single product that comes before the tribunal.
What is the status of a dual fuel case? We've got a decision, which I think is an FTT decision.
That is correct, and so it is awaiting your lordship's decision.
So there's been an appeal to the UT, but they're waiting until they hear what we say.
That's correct.
Thank you very much.
You said a moment ago that the fact that something happens to the product means that it is no longer confectionery.
Yeah.
Don't you have to put it a slightly different way, which is to say that the fact that something is going in the future to happen to the product means that it is not confectionery in the first place?
In the first place. So at the point of sale, it's no longer confectionery. Yes, thank you for correcting me on that. And so in terms of if the commissioners are correct, then you've got hundreds of thousands of retailers up and down the country who still are not quite sure, potentially, which side of the line the product falls, because it's an individual decision, obviously, as to whether to charge VAT at the standard rate or whether to zero rate it.
But whichever you are right, individual retailers have that decision to make, whether it's, as Mr. Watkinson says, if you come with a tailpiece, that's that.
Yep.
Or whether it's, as you say, it's a multifactorial assessment. Yes. Indeed, it might be thought that for individual retailers to have to predict what a multifactorial assessment would result in for each of their thousands of products was a more difficult thing.
Well, I would respectfully disagree with that, my lord, because if there is guidance on the marketing of the product, as my lord said earlier, and then there's really, if you're not into whether something's sweet or sweetened or not, I'll leave aside chili chicken skewers for a while, but nevertheless, it's a potential minefield, if I can put it that way, if the commissioners are correct. Because if the commissioners are correct, and it's almost like the backstop, the be-all and end-all, that if something is sweet or sweetened normally with the fingers, that is going to catch potentially items that should not be within that definition.
I follow the last point, but as to the point of lots of retailers, is that really such a concern? Because if it is decided in relation to any particular product that it's subject to VAT, then the manufacturer or the wholesaler will charge VAT, and all the retailers who then retail the product aren't really going to think about it, are they? They're just going to charge VAT.
If there's a decision, my lord, yes, absolutely.
Or indeed, I dare say even without a decision, if the wholesaler charges VAT, they're going to charge VAT too, aren't they?
You would think so. Absolutely. You would think, yes, you'd recognise my supplier has charged me VAT or not, I will do the same.
Probably.
I suppose the difficulty is speaking practically, and please ask me to move on, is that if your supplier zero rates the supply, but then you think, hang on a minute, it is standard rated, then but you do go on to zero rate it, then clearly the commissioners are going to come after you for the VAT that you should have accounted for at the standard rate. But that may be an aside.
Well, the cases we've seen,
yes,
I don't know how difficult it is, the commissioners seem to go after the producers, Premier Foods and your clients and so on and so forth, rather than a corner shop or so.
Sorry,
isn't that in practical terms where the focus is going to be on the producer? Of the
it has to be, but of course that has a consequential effect on the tax liabilities going down the chain.
I understand.
Maybe going back 4 years potentially.
Yes.
So they've got to correct their liabilities.
In practice, no doubt, as has been said, it will be going after the producers, and then there'll be the knock-on effects. But in theory, if you're conducting a multifactorial assessment, and one of the factors to which more or less weight may be given is which aisle it's in the shop.
Indeed.
Different retailers may have different practices, And when they read our decision, they may all take it out of the confectionery aisle and put it in the world foods aisle if they haven't already done so, and say, well, that makes all the difference. So aren't we in the multifactorial world?
We are.
Likewise.
We are, my lord, and that's
in
the
a
point.
difficult position.
Does that affect whether it's sweets or not, or chocolates, or whether it's normally eaten with the fingers? Because that is what the commissioners want you to find is the only test. And therefore, where it's positioned has got nothing to do with those particular factors.
But you say it does have.
Yes, absolutely. Because previous decisions have said so.
Yeah.
Just moving on to a couple of the cases that the commissioners have cited. I've dealt with Corte. I don't think I need to take you to it. Dual fuel, my lord has asked the question, and we know where we are with that. In respect to the jusum generis applying, then you will notice that the appellant doesn't actually support that in its application. Therefore, I don't propose to make any comment on it.
Yeah.
You were taken to the case of Morrison's, or my learned friend mentioned it, it's in his skeleton. But I think it may be worth just having a quick look at Morrison's, firstly in the Upper Tribunal. Just bear with me.
Can you remind us where we find that, please?
It should be page 448 in the authorities bundle, my lord.
Is that bundle 1 or 2?
It is, it's behind tab 26.
Thank you.
Volume 2. My learned friend took you here before, I apologise, but you can see paragraph 20. Judge Richards has given permission on the following grounds: whether the FTT had erred in law by excluding from analysis of whether the products were confectionery, relevant considerations consisting of the actual perceived healthiness of the products or the marketing of the products as healthy products. Again, that's nothing to do with normally eaten with the fingers or not, whether it's sweet or whether it's chocolate. Second ground of appeal, the FTT had erred in law by wrongly treating the absence of cane sugar, butter and flour from the ingredients as irrelevant to their status as confectionery. Note 5 comes into the equation at paragraph 22. Commissioners argue that even if the appellant was successful on the grounds above, the First Tier Tribunal's decision should be upheld on an additional ground that the products fell within Note 5. And as my learned friend correctly stated earlier, it's whether the products were already sweet in terms of how you read sweeten. Over the page, page 449, paragraph 23, the parties agree here that the First Tier Tribunal was to give the word confectionery its ordinary meaning, to ask what the view of the informed ordinary person was to the nature of the product, whether or not it was one which fell within the relevant category. As both parties acknowledge, this calls for a multifactorial evaluation, and accordingly appellate caution in interfering with that evaluation. They are agree matters of weight for the first instance tribunal. Moving forward to page 472. Paragraph 143. we will remit the matter back to the FTT with the following directions for determination. Paragraph 6. The new FTT shall take as given the following primary findings of fact, but may, as it sees fit, make additional findings of fact on the basis of the evidence that was before the original First Tier Tribunal. Ingredients and process, market and marketing, packaging, purchases. And something similar, but not exactly the same in respect of the naked bars. And as my learned friend pointed out, when the case was heard again by the newly constituted tribunal, I'm going to ask you, your lordships, to go to page 510, so that is at tab 28, I believe. Paragraph 15. This was Judge Sinfield, President of the First Tier Tribunal. You see the final sentence. In the hearing before us, Mr. Watkinson confirmed that HMRC no longer relied on Note 5. Ms. Sloan referred to Note 5 as a deeming provision, which, for example, deemed drained glacé, crystallised fruits and confectionery. We do not think that is entirely accurate to describe Note 5 as a deeming provision. The purpose of Note 5 is to clarify the meaning of confectionery and provide certainty where there might be some doubt about whether an item should be classified as confectionery. Note 5 only operates as a deeming provision insofar as an item which it states is included in the term would not ordinarily fall within confectionery. It's obviously incorrect to say that all the items listed in Note 5 would fall outside the term confectionery without the note. And then paragraph 17, First Tier Tribunal cites Benyon, which have already been taken to. And then also cites Premier Foods, Sir Andrew Morris. So that was just to confirm, should I have needed to, that the only case authority the commissioners can point to in respect to the deeming provision is one where it wasn't actually a deeming provision. It was a label attached to the provision that the Upper Tribunal decided.
Can I ask this? The FTT says that the purpose of Note 5 is to clarify the meaning of confectionery and to provide certainty.
Yeah.
Has it provided certainty on your case in relation to sweetened prepared items normally eaten with the fingers?
Well, that, my lord, is a difficult one to answer. Firstly, because that wasn't the case before that wasn't the decision of the First Tier Tribunal, if you remember.
No, but leave aside what the First Tier decided. On your case, does it provide certainty?
Yes, it does, because the appellant's case was always, it's not, the product is not normal.
No, sorry, I don't mean it in relation to this particular product.
Oh, I beg your pardon.
As a matter of general principle,
yes.
On your case, well, if it is your case that Note 5 provides certainty, how?
It provides a definition.
But not one that the tribunal has to act on?
No, no. If the tribunal feels that it is an issue that it needs to decide as to whether something is confectionery or not, I mean, one could, I suppose, thinking out loud, have a product that, okay, you first think, well, is it a chocolate or not? If it's not a chocolate, is it a sweet? If it's not, is it something, is it a glacé cherry? And you can almost go down the list, if you like. So from that sense, there is a test to which the First Tier Tribunal can, if it feels it needs to, address if the product does not readily fall into another one of those the definitions that go to make up what is confectionery. It doesn't have to consider whether something's sweet or sweetened and normally eaten with the fingers. You've been taken through the 6 complaints, if you like, of the commissioners. I think in the overview of what I've said before you earlier on and this afternoon, I think a fair number of those issues are already have been covered. They're clearly in the skeleton argument. I don't think, to particularly address you on the historical development. You've been taken through it. You see what it is. The appellant's position is there was no intention to widen the scope as broadly as the commissioners say there is. The words used don't say that. In respect to the second complaint, if I can put it in that way, again, it's just going over the same ground, to be honest. No complaint.
Remind us
no criticism.
Second complaint was?
The second complaint was, it's at paragraphs 45 to 47 of the Upper Tribunal. Just bear with me a second, my lord. I'll just make sure I'm absolutely sure I'm not misleading you.
You're working for the grounds of appeal, are you?
What I'm addressing is the way the commissioners have put it in their skeleton argument. So yes. So the skeleton argument is behind tab 2. Starts at page 17. So the first complaint, as I have viewed it, is the approach to statutory interpretation.
I see, yes.
My learned friend addressed you on. I think I've addressed you on that. Clarificatory. Begins at paragraph 36, page 28. Commissioners say there's no requirement in law for the Upper Tribunal to treat every part of Note 5 as functioning precisely in the same way in doing so. And therefore, commissioners say, well, yes, sweets and chocolates was clarificatory, and the tailpiece isn't very deliberate and significant widening of the term confectionery. I put forward the respondent's case that that's not true. Second is the tailpiece itself, whether there's a non sequitur or not. Very short point. I will say paragraph 40 on page 30. Sweets and chocolates were moved from item 2 to note 5 could not logically justify a conclusion that the final Newey did not function to make something confectionery hitherto that it had not been. I confess I'm not quite sure what that's trying to say. It may be me, it may be something that my learned friend can expand upon if he chooses to do so, but I'm not quite sure what that means. But nevertheless,
I mean, it's an echo of paragraph 38, isn't it?
yeah, it is an echo. So, but it's effectively, we're looking at the same argument. We're looking at what, and I don't say my learned friend is wrong in terms of how your lordships, and I'm sure you're very familiar with it, what it is that you actually can and cannot do in terms of interpretation. But just to reinforce the point, the appellant, normally on the other side, the respondent says that the words used by Parliament, whether you take into account the extrinsic aids or not, do not have the effect of significantly widening the definition of confectionery. The third complaint begins at paragraph 41 of the skeleton, that's on page 30. And I've already addressed you on this before. Replacement of the phrase similar confectionery with any item of sweetened prepared food which is normally eaten with the fingers. There was no definition of what normally is, and it must be different for individual products. There has to be an MFA, or at least evidence, a fact-finding exercise carried out to establish what is normal in each individual case.
What form would that evidence take?
Well, it's a difficult one in a way, Milo, because it's an objective test used by the man in the street, informed as the tribunal had been informed. And that again goes to partly to packaging, as it was in this case. So the packaging in this case was, there was a description of for roasting, let the product cool before you eat it.
Yeah, but I'm just wondering what, in practice, in order to prove normally, parties are supposed to do. Are they supposed to call a man in the street as a witness and say, I think these would normally be eaten with the fingers, or not? Or would they commission some kind of market research? I mean, what would the evidence be?
And there is in the point of why, if it is a deeming type provision, it's unworkable in a sense. What evidence do you bring? You're absolutely right. And in the appellant's case, there were graphs, statistical graphs and data to show that there were increases in sales around, I think, from memory, Halloween, where it would be normal, perhaps New Year.
No, that's got nothing to do with normally eating with the fingers.
No, sorry, you're absolutely right. I got off on a tangent there. I do beg your pardon. No, but so whether it's normally with the fingers or not, I don't know. I don't know. I'd love to have a case where it is, to be perfectly honest, and then I'd be able to turn my mind to it.
If Mr. Watkinson gets his remission, you might have one.
Well, that's a possibility. I hope not. But thank you. So yes, I don't know practically. I don't. The fourth complaint begins at paragraph 49, page 32. This is the point that we've already discussed about whether something is akin to a rebuttable presumption or not. So just to clarify, if an assessment is issued by HMRC, unless there's an allegation of fraud, then the the burden of proof is on the appellant, taxpayer, to prove the assessment is wrong. That doesn't necessarily extend to, but may, whether burden of proof is on the appellant, i.e. the taxpayer, to prove whether something is normally eaten with the fingers or not. If that is an issue.
Well, why not? If the burden is on the taxpayer to prove the assessment is wrong, and if the determinative issue is whether it's eaten with the fingers, then it would be.
If that is the nub of the, if that is the only thing that's an issue,
Yeah, I see.
I agree. The fifth complaint, paragraph 51, page 32. Then chili chicken skewers make up their case. I won't address you on those if you don't really want me to. I don't intend to. But personally, I don't see how a meat protein product can ever be confectionery. And then paragraphs 53 and 54 seem to, and I'm not pushing this far at all, but they seem to be getting into facts. For example, if a small was sold ready-made, it would also be confectionery. Well, it may not be. They may be sold as biscuits. Who knows? But my point is, if the commissioners have already said there is no challenge as to the facts as found by the tribunal. And I'm sure that this and the second ground of appeal is not a way that the commissioners are just trying to shoehorn in an argument as to having to go back to re-examine the facts as found by the first tier. Finally, in ground one, sixth complaint, paragraph 55, the UT's general approach amounts to a narrow or strict interpretation of confectionery. There's the appellant says, the respondent says, well, that's not correct. There was no narrow or strict interpretation. As alleged. My learned friend is absolutely correct if it needs to be made any clearer, but he's made it perfectly clear. When dealing with zero-rated products, yes, there is a strict interpretation of the language used, and if there are provisions to take a product outside of zero rating, so back into standard rating, then, as your lordships have clarified, it's just an ordinary interpretation. Ground two, whether the FTT was erroneous or not. Clearly this is one of those cases where you have to read the decision in context, not cherry pick any particular paragraph or paragraphs. Same with the Upper Tribunal's decision. And just to echo, if I may, First Tier Tribunal must have been aware and were aware of Note 5 and didn't articulate it as to whether they'd taken it into account or not. But the inference from the decision, as I've said several times before, and I apologise if I'm repeating myself, it made the decision on the basis the product was roasted. And it made findings of fact which have not been challenged to that end. In terms of the Commissioner's position as to whether the matter should be remitted back to the First Tier Tribunal if your Lordships do find in the Commissioner's favour, the appellant says, of course, First Tier Tribunal did not make an error of law. If it did, was it material? Well, it can only be material if your Lordships do find that Note 5 should have been taken into consideration and should have considered the tailpiece.
So I missed that last word. Should have
And should have considered the tailpiece. My lord.
tailpiece. Tailpiece. Thank you.
Which, of course, the appellant says it did not need to as part of its assessment as to whether the product was confectionery or not.
Do you agree that the FTT did not in terms decide on the tailpiece whether the product is normally eaten with fingers?
I agree that it didn't decide on that on the basis that it didn't need to.
That's what I thought.
Yes. And also, if I might turn my back for a moment.
Please.
Thank you. Yeah. Yeah, thank you. I'd forgotten to mention cooking chocolate. I do apologise. I'll mention it very briefly. If Note 5 is, as the Commissioners say, then it wouldn't matter, again, because it includes chocolate.
Well, it includes chocolates.
Yes.
No. Yes.
Which, I mean, chocolates obviously include things like milk tray, box of milk tray. Do they include slabs of chocolate?
Well, that is a question that's not been asked before. Maybe that may open a new line for my learned friend and I. No, and that is a good point on the assumption that chocolate includes chocolates and vice versa. Then again, we have this question over cooking chocolate of what it is going to be used for. My learned friend says, well, there's a difference potentially between sweetness and cocoa content and whatever. But again, that makes this sort of unworkable.
A bar of chocolate, which after all is not just raw chocolate, but is sweetened.
It is.
Would fall within the tailpiece.
It may well do.
If chocolates is limited to the milk tray.
If it is, yes, no, that's a good point. A good point. Yes, my lord, it would. But again, I will say, chocolate is chocolate. It's the use that it's going to be put for that potentially takes it outside of Note 5.
Well, that's why cooking chocolate would not be within the tailpiece. But a bar of chocolate.
But that's the intended use. But who knows? People may like the taste of cooking chocolate and buy it because it is cheaper than their 70% bar of.
Well, that comes down to normally.
Yeah, exactly. Exactly. Just bear with me one more time.
Yeah,
if I know. There's nothing further unless I can help you.
No, thank you very much. Mr. Watkinson.
My Lord, very briefly, in reply, on the tailpiece to Note 5 being an enlarging provision, my learned friend's argument as to the contrary, in our respectful submission, amounts to simply reading the extrinsic aids referring to cereal bars without looking at the wording of the statutory provision, without looking at the history, and without looking at its context. It is precisely the same error of which we complain the Upper Tribunal fell into. So we submit it. It is no good simply reading cereal bars in those two documents and deciding that that determines the scope of the tailpiece.
I'm not sure he accepted the cereal bars necessarily were confectionery.
No, well...
I mean, going back to the problem that was identified in the doubtless inadmissible correspondence that's attached to the intervener's skeleton, one sees that there was a concern over hard cereal bars, lest they be thought to be like biscuits. And I understood Mr. Brown's position to be, well, maybe it's still open to manufacturers of such bars to have the argument.
Yes, that was the position as put forward, and that is part of the package whereby manufacturers or whoever defends an assessment can really bring forward anything and say, well, it doesn't matter that there's a statutory definition. It doesn't matter that our product answers to that. You can ignore it. That's the blunt effect of the respondent's submission. To the extent, he says, that the FTT in this case were fully entitled to ignore Note 5, to simply not bother determining HMRC's case that you were taken to in the skeleton at paragraph 17 about whether the product met Note 5. It simply begs the question, my lords, if my learned friend is right, what on earth is the purpose to having a statutory definition at all? There's no purpose to it, if my learned friend is right in his submission. Note 5, as my lord has already identified, is not an exhaustive definition. It's only inclusive. If a product doesn't fall within one of those descriptors, of course it must still be capable of answering confectionery on general principles, or there's no point to having a non-exhaustive definition. So in our submission, based on the architecture of the statutory provision itself, there must be two ways of approaching a given product. Does it answer a descriptor in Note 5, in which case, but for absurdity, it's confectionery? If it doesn't, does it answer to confectionery on general principles, the multifactorial analysis? That we submit as the only way in which an inclusive definition like that, deliberately non-exhaustive, can work. So we don't say that there is only one test, which is the respondent's submission. So we submit it's entirely wrong to suggest that a statutory tribunal can simply decide it doesn't have to act on, in my learned friend's words, statutory definition because it wants to consider or feels that an issue it needs to decide has come up, it can somehow set that aside. It's wrong simply as a matter of principle. And that really is the fundamental argument that my learned friend puts forward, and if my lords dismiss that, then what one's left with whether ours is correct. So as to ground 2, it's a similar iteration of that point, that the learned friend says in his submissions that the FTT, one infers, decided it didn't need to consider Note 5. And it's accepted that it didn't answer it on the face of the definition. It's a perfectly orthodox error of law that if one just doesn't answer the case put forward by the party, fundamentally, that the judicial function has not been discharged. So even on my learned friend's best case, the FTT has erred in law by just not answering on my learned friend's submission consciously the revenues case in the first tier. When one then goes up to the Upper Tribunal, it's a question of whether that was defensible, and we submit that the Upper Tribunal made its own errors of law for the reasons I've submitted, and that my lords will be glad I'm not going to repeat. So unless there's anything else that's arisen, and if I might briefly turn my back, my lords, those will be our submissions in reply. Unless there's anything else, my lords.
Just one question. Given your criticisms of the FTT, if we were to remit the case, do you say we should remit it to the same tribunal or to a newly constituted tribunal? And bear in mind also that that may have an impact on whether they look at the existing evidence only, or whether they invite, or we allow them to invite, a whole load of new evidence.
My lord, in my submission, the better route is remittal to an FTT that is fresh, and that is simply to avoid the appearance that if there is to be any criticism, that the FTT feels it's in some way defending itself when it comes back to it. So it's normally said on this issue that to avoid any issue of appearance as to that, and of course, there's no suggestion that Judge Cannon or Member Bell would be in any way biased, but to avoid that kind of appearance, ordinarily one would look to remit to a fresh FTT. Likewise, one could understand, if my lords felt it a simple matter of law, that one could do it to the same constitution. Our submission would be the better course is a fresh one.
If one were to take that course, how does it work? The appellant's evidence, the original appellant's evidence, not the respondent's evidence as now, would be the written evidence put in before the witness statement, but there would have to be a fresh chance for cross-examination, presumably, because the...
Yes, it would be a complete rehearing ordinarily, my lord.
A complete rehearing with an opportunity to put in completely different evidence, or
well,
a complete rehearing starting from the point at which the tribunal was when it started to hear the case.
One can tailor the form of remittal to what this tribunal thinks is fair. So in a similar way, the Upper Tribunal in Morrison's, when it remitted, said that all the findings of fact that FTT had found were to be left intact. The fresh FTT could come to its own additional findings of fact, but one didn't need to traverse all the evidence.
To what extent was there oral evidence? The FTT refers to the evidence from a Mr. Foster, but says there was no real dispute in relation to his evidence.
I don't detect, and my learned friend was there, I don't detect that there was actually any cross-examination.
Was he cross-examined?
Desperately trying to remember, to be perfectly honest. Yes, he was. He was cross-examined, but not necessarily on everything, as I can. And those behind me are pushing forward, but I generally don't remember.
Well, you won't remember the answer to this question then, which is was he cross-examined on the question of normally eaten with the fingers? I would rather doubt it, because I'm not sure he would be in a position to give evidence about that.
I'm sure he wasn't.
So the corpus of evidence is there, whether for a new tribunal or the same tribunal, if that is what we decide.
In theory, yes.
And my lords would also doubtless have regard to what my learned friend has identified and the concession that findings of fact on general confectionery are now beyond the pale for that. Unless...
I think if we got to that point, we would only be remitting on the tailpiece.
Yeah. HMRC's case, as was put in the original skeleton. So I make that point clear that would doubt, if my lords were considering remittal, that would be uppermost to ensure that there's no unfairness in HMRC having that extra bite of the marshmallow. Yeah.
Big
Big marshmallow. So, my Lord, those are our submissions in reply.
Thank you very much. We won't give judgment here and now. You will, of course, be supplied with the judgments in draft before they're handed down. We'd be grateful if at that stage you would seek to identify errors in our English and typing, but that won't, of course, be an opportunity to re-argue the case. We'd be grateful if also at that stage you would seek to agree an order dealing with consequential matters. If there are any points on which you can't agree, could we please have brief written submissions, and we would expect to rule on those points in the order that we make. I ought also to be on the safe side, I know you're all very familiar with this, to remind you of the importance that's attached to the embargo. You've already supplied contact details. If you think of anybody else who needs to see the judgment in draft, obviously you need to come back to us. But that apart, thank you all very much for your submissions. Thank you also to those who haven't had speaking roles. We'll